Welcome to Property Law 101. I'm Sara Bronin, and I created this series to help you understand the basics of property law. This series covers 4 fundamental questions about property law, and today we're talking about the second question, which is acquiring property. And we are specifically talking about adverse possession, a legal principle that allows someone to acquire ownership of land by actually possessing it for a statutory period under certain conditions. Another video shows the elements of adverse possession, and yet another video explains the rationale for it. It is so common and so well justified by scholars and legislators that every state allows some form or another of adverse possession. But the vast majority of states also have placed certain limits on the way adverse possession is used. For example, one of the justifications for adverse possession is that it encourages us to use land more productively. But some states say that maybe we don't want all land to be used productively. What about environmentally sensitive land, historic properties, conservation land, and the like? So these states, including Connecticut, say that land owned by certain entities or used for certain purposes cannot be adversely possessed. What about, more specifically, government land, whether the government land is being used or not? Should we allow adverse possession of public land? Some people think that we should. Some people say that government is just like any other landowner and we shouldn't treat it differently. If government sleeps on its rights, government loses property. But many others think we should treat public land differently. The theory here is the king, the government, doesn't have time and shouldn't be expected to monitor all of government property all of the time. Lots of land, especially out west, is in public ownership. It would be nearly impossible for government to continue to monitor every inch of it all the time. That is the rationale that has prevailed in most places to totally prohibit adverse possession of public land. That is true even if the government is not actually putting the property to any specific use. Some states do allow government property to be adversely possessed, but in very limited circumstances. Another reason to not allow public land or certain lands to be adversely possessed is that we want an orderly distribution of land, not necessarily a free-for-all. One example of orderly transfer of public land is more specifically the process for obtaining mining permits on federal land. These are essentially access grants to mineral estates underground. Another example, maybe older, are the Homestead Acts from 150 years ago. Those set out special rules about how settlers could establish their rights to public land, out west primarily. Finally, state laws may limit whose land can be adversely possessed. So consider people with legal disabilities. That means people who are too young, who are legally insane, who are legally incompetent, or even incarcerated people. State laws address these legal disabilities in a variety of ways. Perhaps the most common way is for state laws to limit the tolling or to toll the statutory period during the period of the disability. So if the disability has occurred first after the initial point of adverse possession, the period is tolled. If it hasn't occurred, then the statutory period for adverse possession will not start until the disability ends or is cured. So other states treat a situation where an adverse possessor is claiming land from someone who is the true owner and is disabled, is that once the disability is removed, the state shortens the statutory period by some amount. All of this is to say that there are some limitations on adverse possession. And as you think about these limitations, consider who the limitations benefit and what values, what social values they enshrine. I will leave it there, and I would love to hear from you in a variety of formats, whether Twitter or through my website, and I will see you next time. Thank you.